highlights really a face-to-face conference is the lunch. That was much less awkward when it's online. And you get told you've got a lunch break now, and you go, what do I do? I'm used to having a lunch break in my house. But anyway, so we're moving on this afternoon from our comparative study this morning of different jurisdictions to instead looking at different areas of law and different legal problems that arise in relation to cohabitation, de facto relationships, call it what you will. And we're starting off with a session on academic perspectives, looking at 4 different areas with the 4 leading lights for each area talking about them, all of whom need no introduction. But unfortunately, the format means I've got to give a superfluous introduction. So we're going to kick off with Professor Anne Barlow from the University of Exeter, who's going to be talking about the common law marriage myth, which has already sort of arisen a few times this morning. Anne, of course, is Professor of Family Law and Policy at the University of Exeter, with a special focus on adult relationships. And in terms of what she's speaking about today, she's well known for her empirical research proving the existence of the common law marriage myth. Anne's going to be followed by Andy, who's already been introduced once, so I'm not going to do it again. That's completely superfluous. And then we've got 2 online speakers, Dr. Brian Sloan, Assistant Professor in Property Law at Cambridge, a fellow of Robinson College, who's published prolifically on the law of succession, will be speaking about the Law Commission's work in terms of intestacy. And then finally, last but not least, we've got Professor Rebecca Probert, Professor of Law at the University of Exeter, well known for her work in family law, and in particular on the history of marriage, author of numerous works on that, including an excellent monograph published last year, and also was the specialist consultant to the Law Commission's recent work on weddings. So she'll be talking about that and religious-only marriages. That's more enough for me. I now hand the floor over to Anne to talk about the common law marriage myth.
Thank you very much, Russell, and thank you for inviting me to this really important event. As many of you will know, I've been researching cohabitation for a very long time now, far too long probably, but I'm not going to give up. I think we need to keep pressing on. And the reason I think that in particular is because in England and Wales, this common law marriage myth phenomenon, as I've called it, continues to persist. Now, if I can work the slides, that's good. So we know that the way we do family has changed. You know, this sort of love and marriage no longer go together like a horse and carriage, and we know there are growing numbers of what were called non-traditional families. But what to do with them, as we've seen from the wonderful comparative work, I can't wait to get my hands on Andy's book, shows, is that actually everybody's struggling to some extent in knowing how to respond to these phenomena in a way that seems appropriate. Now, of course, in England and Wales, originally it was heterosexual cohabitants, some presumptive law situations where the need arose, and it was all very ad hoc, and maybe for succession, and that was a thing, tenancies, or maybe inheritance. Oh yes, cohabitants, maybe they should have a right to apply in a similar way, if not identical way, to a spouse. But more recently, we swung towards a more formalized approach to saying to cohabitants, this is what you should do. You should become a formalized couple, recognized in law, and then everything will be fine. We don't have to worry about the informal couples, as they're sometimes called, the de facto couples. And obviously that is a view that you offer marriage, you offer civil partnership, you do that equally for same-sex couples, opposite-sex couples. But is that going to include what family law's function should be in relation to growing types of families. So we know that at the moment we're still in this state of flux. We've got a bit of, well, quite a lot of law in different contexts, which does recognise cohabiting couples, and we have other situations where they're just regarded as separate individuals. But what we also know is that marriage rates are declining. That's true here. Same-sex marriage is very popular, but heterosexual marriage less so, still in decline on the long-term trends. And we know the law remains complex and confusing for de facto couples, as we've already heard. So back in 1996, Rebecca Bailey-Harris, a barrister and an academic in those days, pure and simple, she said the statistics speak for themselves. We need to reform cohabitation law. And she was one of the first people to sort of pick up the baton and say, we've got to do something about this because the world has changed, the way we do family has changed. And what is the law going to look like if we don't keep up with those trends? And we're still in that situation, sadly. We've seen lots of movement, but we don't have proper recognition of the legal status of cohabitants yet, not in a cohesive way. Yet cohabitants are a fast-growing family type, 3.6 million couples, okay, far fewer than married couples, but still a big chunk of the population. And it's a 23% increase over the last decade, and that graph is still going up. There are a lot of children involved in these families as well. 1.3 million of those couples have dependent children. Cohabitation has also changed older couples, and perhaps that is more of a sort of legal decision. They decide to cohabit, perhaps they've died, their original partner has died, say, or they've been divorced. We know that that is also a phenomenon. So the spectrum of cohabitation has got a bit more complex. It's not just, as Catherine was saying about Ireland, a sort of pre-marriage cohabitation that just exists here. We have it at different points of the life course, if you like. And also, I mentioned this, and I know others are going to speak more about it, but in law, if you have a religious-only marriage, a non-qualifying marriage, so-called, then you are regarded as a cohabitant. It's not regarded as a void marriage. You don't get any of the Matrimonial Causes Act remedies opened up to you. You are a cohabitant in law, yet you are probably totally unaware of that, and you regard yourselves as married, yet the statistics, the ONS statistics, I'm sure for anybody being asked in one of those marriages, they would tick the marriage box, not the cohabitation box. But in terms of numbers, there's a bigger constituency of people that are affected by cohabitation law. I mean, your models have all overtaken this in your book, I think, but, you know, in terms of the way I discuss things with the students, you know, what should we do about cohabitation law? You can take the Napoleonic approach, because apparently, apocryphally, Napoleon said cohabitants ignore the law, so the law should ignore them. And certainly, you know, Ireland, until their new act came in, that was their approach. And I think in Greece, that's pretty much still the approach, or there seems to be some concessions perhaps there from what you were saying this morning, Andy. You have an opt-in approach in France. The Pact was one of the first. The Netherlands had registered partnerships that were equivalent to marriage, unlike the French approach. And now the UK, you could say we've got an opt-in approach. As we've seen, Australia, New Zealand, and Scotland, now Ireland, have a sort of opt-out situation. So yes, the law applies to you, but you do have the right to take a step back and say, I don't want to be included. And then I quite like, because it's everything to everyone, I think it was Aragon, one of the Spanish regions, when we were looking at this some time ago now, and things have probably moved on, they had a sort of pluralistic approach. So you could opt in, but a court could also decide at any moment that actually, even though you hadn't signed on the dotted line, they could apply this law to you because it was appropriate. And that sort of where you want to get to, I think, a sort of pluralistic approach that does take it. But how to do that without having every single couple that breaks down go to court and have a suitable answer is, of course, another issue. So in terms of England and Wales, we've got a piecemeal approach to informal couples, and we've tipped away from these presumptive remedies being extended towards an opt-in approach. Although, having said that, of course, the bereavement news has perhaps gone back to more of a presumptive approach where some cohabitants will be recognised as spouses in other contexts, but it's very piecemeal, and you just don't know as a cohabitant where you stand. You know, given it's so common, one of the problems is the complexity of the law, that the fact you don't know until you get to the end of the relationship that you are in this situation, and then you've got no route back. So what should we do, and what about this common law marriage myth thing? Well, you know, we got this opt-in reform in England and Wales. That's great for opposite-sex civil partnerships. That discriminatory period where only same-sex couples could become civil partners has gone. Equal marriage, equal civil partnership, we've got there. And that does chime, the ability for opposite-sex couples to make a civil partnership if they want to do that, enter into a civil partnership, chimes with public opinion. The research that we did alongside the common law marriage research, which I will come to in a second, says that 72% of a national panel and 66% of a wider panel agreed that you should have equal civil partnership, and only 7% disagreed that should be the case in the heterosexual context. So some sort of idea of having a choice for people about the different styles of relationships, that does seem to chime with public opinion. And I think where we go from here, from my point of view, is that we need to look at relationship generated disadvantage, because we've had further reform of divorce law. So marriages and cohabitations, the old arguments used to be, well, you know, a marriage is a commitment, it's a lifelong commitment, and therefore we recognise that when relationships break down, you have to have a reason for getting out of that marriage contract of one sort or another. None of that applies anymore. We have unilateral divorce if we want it effectively now, as of last year. And so, you know, what is the difference between cohabitation and marriage? You could argue there's been a convergence, if you like, in terms of what those relationships mean. You know, apart from the party and the wedding, that what stands behind getting into and out of these relationships is much more similar than it used to be in former times. And but yet relationship generated disadvantage, which is only recognised in the marriage and civil partnership context, definitely happens, as all practitioners I'm sure will have heard, in the cohabitation context as well. And I think that is a real issue that we can't just leave hanging unless family law no longer plays that protective role and is going to stand by its quite normative stance, if you like, of only accepting that certain types of relationship are worthy of family law regulation and therefore should be privileged. But I think the reasons for privilege are less clear than they used to be. Plus, if you're going to have if there is cohabitation law that is different from marriage law, you could at least make it cohesive in some way so that people knew where they stood. So even if you're not going to get marriage equivalents or civil partnership equivalents, then at least be clear about what you are getting. And we don't even do that, because in some contexts you're treated as married or civil partnered, in other contexts you're treated as similar to but not quite as good as married and civil partnership couples, and in other contexts they say, well, you're just two individuals, you just do your own thing. And as we've talked before this morning, autonomy is the autonomous legal subject is sort of driving this, that people know what they're doing. They're choosing marriage, they're choosing cohabitation, and these are quite different things that people are choosing, and therefore this differentiation of the regulatory approach is justified. But I really still hold by the view that we need to look harder at the functional similarities or indeed differences of cohabitation and other couple relationships that are, if you like, better regulated in the context of relationship generated disadvantage, because of demographic change, equality issues, the social acceptance of cohabitation, and yes, I am going to get onto it, the common law marriage myth. So when I was in practice, people used to come into my office and they would tell me they were married. And I'd say, well, can I? And they wanted to get divorced. That was the thing. And I'd say, well, actually, to get divorced, you need to give me your marriage certificate. Seems a bit strange, but you do. And they say, oh, I'm not married like that. I'm married common law. And, you know, there was I, hard as it was to believe, you know, I'm 23 and I'm saying, well, actually, you're not married and you don't have any rights. And in those days, you really didn't have any rights, fewer than you have now. And they were literally off down the road to find a solicitor that knew what they were talking about. I mean, I am really serious. I had people who were sort of out of the door saying, oh, you know, she's young, she knows nothing. It's really embedded. And then when I became an academic, I thought, well, you know, is this a real thing? Is it just wishful thinking on the part of people who cohabit, which was one of the theories that put around, or that was being put around, or is there something a bit more? You know, is it just cohabitants who think that, or is it wider? So we've done now 3 tranches of nationally representative research looking at cohabitation and marriage, and in particular the common law marriage myth, and what people at large in the population think about that. And as you'll see, we found it's very embedded that at first a majority of all the population, and even now close to majority of the population, regardless of their marital status or otherwise, do believe in that they get the same rights as if they were married. Not just similar rights, but the same rights. We asked that very specifically. There was So we did that first in 2001. There was a government, you may remember, the Living Together campaign that tried to raise awareness following that. And so after that, we then did some further research, which showed that the belief in them had gone down a bit, but not that much. You were still having 51% of the population and 53% of cohabitants who still believed that they had the same rights. So in 2018, there was, when the civil partnership debates were going on in the courts, etc., I thought, well, let's see, has it changed? Have people finally got this, that they don't have the same rights? Because again, there'd been a lot of publicity. And essentially, as you can see from those graphs, yes, it's gone down, but 47% of the whole population nationally still believe in the myth. 40% disagree, so people are, if you like, it's going up, as you can see, from 37 to 40 there. But if you look at the numbers that don't know, those have increased as well. And if you add the sort of don't knows, you know, you can see that it's not very clear. People are not clear about what the law does or doesn't do. So I hope that I have shown that the common law marriage myth is still alive and well, despite the best efforts of us to change their thinking on that. And then what I've done, I hope this doesn't get too boring, but we've tried to look, because one of the things about this is, you know, is it generational, or is it sort of a serial line in the data, if you like? Will people, as they go through life, you know, adopt different beliefs about this? Or will the younger generation actually, when they get to the situation where they have children in the cohabitation relationship, will they remember that it's all very different in law? Or will they also become victims, if you like, of the common law marriage myth? Well, anyway, so here are some of the stats. 48% of cohabiting couples, more or less the same as married couples, do believe in the common law marriage myth, and that has come down since we conducted the research in 2006. Single people are the least likely to believe it, so maybe they're single for a reason. And 41% of households without children do so as well. So that's lower, but you know, it's still around 40%. That's quite a bit of the population, if not quite half. But those that it affects most, arguably, the people who have that joint enterprise of looking after children, of caring and sharing that care in some way or another, often with dividing those breadwinner and house childcare roles differently, not equally. 55% of all households with children, whether they're married or not, think that common law marriage myth exists. And in previous research, I haven't done this, but when you ask people whether they should get the same sort of rights, then people are, with children, are very much in favour of that in England and Wales, in contrast to what Kate was telling us is the position in Scotland. So where there are children, public opinion seems to be saying, well, what's the difference? Which is, what a lot of people who you speak to think, more in an ad hoc, anecdotal way. But another thing that's interesting, because particularly in light of the fact that the Women Equalities Committee have looked at this, is that actually more men than women believe this. And that's the exact opposite of what it was in 2001 when we first looked at the data on that question. So women are becoming more legally aware, perhaps, which is a good thing. And then people who have a religious affiliation are more likely than those without one to also believe in it, which surprised me, but there you go. That they also think that. So there are large sectors of the population that you might think would be, well, not wanting to distinguish, but more aware of the distinction that don't. So it's very embedded, as I say. And actually, as we were hearing, somebody was also saying that the less well-educated you are, the more likely you are to believe. But even so, 50% of those with degree level believe in the common law marriage myth. And I think that's quite shocking because, what are universities for? So as I say, is this a generational change? And if you look at the age gaps, the knowledge gap in the different age groups, only 28% of those 18 to 24 believe, but 44% didn't, so that's quite high, but 25% are unsure. So again, what will that 25% do as they go through the age ranges? Over 65, 39% believed in it, so that they're more astute, if you like, in terms of what the law actually is, and 53% who don't. 52% of respondents aged between 25 and 64, though, believed it. So that's over half of that group that actually are the most directly affected, you could argue, in terms of the consequences of a relationship breakdown. So I really don't know why this myth is still there in lots of ways. I've got some theories. One is that the whole phrase common law marriage myth sort of has imbued cohabitation with a legal meaning that the law doesn't imbue it with. So that the phrase hasn't helped. Also what Simon Duncan calls lived law, the idea that you get experience of how the law treats you when you have interactions with the state. So if you apply for welfare benefits, you're treated as if you're married, and then you transfer that to your pension claim several years down the track, and surprise, surprise, you're not treated as if you were married when you're cohabiting. So there's this, but while you're building your experience, before you get to those points where somebody dies or you're trying to claim a pension on somebody else's contributions, a lot of interactions with schools, even if you look at car insurance, common law spouse is a phrase that is there on most car insurers. You are classified as if you are married or indeed civil partnered in those contexts. So that embeds it as well. Plus, I think people think the law do what they think people are doing and who should be protected. So there's a sort of element that perhaps this is how it should be, and falsely they think the law will reflect that because times have changed, and that, as we know, haven't been. Does this myth affect behaviour? Well, maybe to some extent. These are some of the people that we've interviewed. We did a national study, and then we picked up followed up on some of the people in interviews. And as Diane says, what's the point of getting married? We're classed as though we're married. We're living together. If we split up, we'll do what married couples do, split everything, kids' responsibility, everything, lots of myths in there, but including the common law marriage myth. Others don't think in a legally rational way. They do what's best for them and their relationship, but they don't actually factor in the legal or lack of legal consequences. So Susan doesn't see it as being married or not. What I do is compare my relationship with the previous relationship, regardless of the fact that I was married to one and not to the other, and it's how happy I am. And how the relationship's working, and that's much more important than the fact that one was a marriage and one isn't, unless somebody dies or unless the relationship breaks down, and then you're in a completely different situations, and people are unaware of that. I think that's the trouble. Maybe young people are becoming more legally rational. I think maybe that is the case, but it's certainly not certain, and we're not there yet. And this fact that you've still got 55% fixed on that myth of the most directly affected group, couples with children, I think is a good reason enough to take some presumptive action. We know that the myth is not the only reason people don't marry, and we've seen across the world that marriage is in decline in a lot of jurisdictions. But we also know, I think, that why people marry or not is not actually to do with legal rights in most cases. They do it for other reasons. So the law, I would argue, is falsely presuming a legal rationality that doesn't exist with many couples. Often, if you've been divorced, you may not, you may appreciate it otherwise. So is civil partnership enough? Well, I think it's complicated because we've got different types of cohabitants. This is a typology that myself and Janet Smithson devised, but we've got ideologues who oppose the patriarchal baggage of marriage. I think they're exactly made for civil partnership, equal civil partnership. They will civil partner because the reason they're not marrying is not because of the common law marriage myth, but because they know they didn't want the patriarchal baggage of marriage. But romantics, really, they believe in marriage. They're often living together. They want a proper wedding. The longer they live together, the bigger the wedding, the more they have to save, the longer they cohabit. They value marriage, but they're not treated as marriage if things do go wrong before they eventually get around to it. Pragmatists, they will perhaps civil partner or marry if they find out, but often pragmatists are common law marriage myth believers. They just don't know. And then the real trouble, I think, is the uneven couples, where one person has the knowledge, the power, the money perhaps, and the other is ignorant, if you like, or less knowledgeable about all of those things. So where are we? Well, I think our legal provisions, as others have said, are really not up to the job of regulating this increasingly large population. We know there are problems with Schedule 1 of the Children Act, although it's better than nothing. We know that the trust law is complex, and it's not easy to access any of these remedies with lack of legal aid and the cost of legal proceedings. I think in 2023, the common law marriage myth is still there. It's not going away quickly. Social attitudes that we, as I say, we've done show that people with children are regarded as if they're married anyway, and that there is a feeling they should be regulated in that way. And despite giving all of this evidence to the Women and Equalities Commission, and they were very good at recommending the sort of law commission approach to reform. That's not going to happen given the government has rejected it anytime soon either. So yeah, some concessions around education, pensions, the bereavement situation, but we're really still in pretty much the same position. So I'm going to finish now, so I'm out of time, but, it does take two to marry or civil partner. So, it's not like that both members of a couple are necessarily choosing to cohabit. And that really knocks a hole, as well as the common law marriage myth, through the idea of autonomy and choice. I think still that a presumptive approach with opt-out obviously is better. I really don't think cohabitation relationships are necessarily more autonomous just because marriage or civil partnership isn't involved. And I do think actually the current law is a women's equality issue because the caring that affects your relationship generated disadvantage and the financial consequences of cohabitation breakdown falls still mainly on women. Sadly, it hurts me to say that, but it does. We don't have a dual earner model. Well, we have a dual earner model, but it's a part-time earner and a full-time earner model, which means that there is economic disadvantage suffered, and we have no real form for redress of that. So I think I'll leave it there. Thank you.
Super. So I'm a glutton for punishment, seeing as I'm coming back for a second paper. And this is in relation to equal civil partnerships and the dimension that they add or they bring to the questions of cohabitation reform. So when Anne showed me her slides for her presentation, it was quite good that they would dovetail quite nicely with my presentation, in the sense that I'm going to be really picking up some of the misconceptions, miscommunication we see around civil partnership reform. And in particular, I'll be dipping into the Hansard parliamentary debates. And as we know, it's still early days. So December 2019, New Year's Eve was the first day in which we could actually enter a mixed-sex civil partnership. We then had the pandemic affecting all the statistics in terms of uptake. So we still need time to really work out the implications of equal civil partnerships and how they connect with cohabitation reform. And in a nutshell, I'm going to be saying that they don't connect and that we really need to break that connection. So I'm looking at this in this presentation between some interrelated research questions. So looking really at this relationship between civil partnership cohabitation. What are the early indications as to public receptivity towards mixed-sex civil partnerships? As I said, there's no hard data yet available. There's some ONS statistics in terms of uptake, but there hasn't been really a detailed empirical study of this. And I'm going to be making some tentative conclusions based on some of the media discourse that we see. And then more importantly, I want to look at whether or not civil partnerships can assist cohabitants and that connection also with the transformative potential that they're meant to have. Some people have lauded civil partnerships for the way in which they're a clean slate, they're a construct of statute, they could be used creatively. And I want to be really testing some of those arguments. So just a little bit of a crash course through the history. As you know, not at all a smooth journey to equal civil partnerships. We ricocheted all over the place. We had part 2 of the Civil Partnership Act introduced obviously for same-sex couples only. We then decide we want obviously same-sex marriage, and we need to get that at all costs. We don't want to confront at all the question of civil partnerships. We kick it into the long grass by section 15 of that act that compels a consultation. So if it gets difficult, try and get an inquiry. They do this consultation, and it's by the Department of Culture of Media and Sport, obviously known for their family law expertise, and they produce rather inconclusive findings and results. In the meantime, we have the litigation by probably the archetypal ideologue couple under Barlow and Smithson's typology, Steinfeld and Kuyden. Goes up to the Supreme Court, and we find that in a unanimous decision handed down by Lord Kerr, that we actually have got a breach of Articles 8 and 14 of the Convention. But here is where we start to get those misconceptions arising. The media coverage of this case said that they'd won a right to a civil partnership, which just simply wasn't the case. All we know is that Section 4 of the HRA was invoked, the Declaration of Incompatibility, and the mission was really to remove that incompatibility. And the court didn't have a preference one way or another. You could close down civil partnerships and just have marriage, or you could open it. They just needed to do something. And that the indulgence of time, which is what the government was seeking, was just not acceptable. We then get in the background through the work of Tim Lawton in the Commons and also in the House of Lords, Civil Partnerships, Marriages and Deaths Registration Act. And Section 2 allows the Secretary of State to create regulations. They then happen. And we have an interesting set of regulations criticised for the use of Henry VIII powers and clauses. But effectively, we get our civil partnerships in on New Year's Eve. Now, in terms of where we are currently with equal civil partnerships today, when you look at this, it's not really a masterclass in law reform. I would say it's reactionary, it's unprincipled, it's top down. It's really the government begrudgingly bestowing civil partnerships. There was no real policy initiative to begin with about the values or benefits of civil partnerships. It was just something through fierce, dogged lobbying. So if you look then at what the Equal Civil Partnership campaign is really doing now, it's disbanded. It doesn't really have any kind of active role to play anymore, but it is performing advice and also trying to connect people who want a civil partnership with witnesses. So that it does have a social media presence, but it was there all the way through trying to kind of shepherd this evolution of civil partnerships. Now, for me, that evolution is not necessarily a problem, because if you look at comparative family law, a lot of civil partnership regimes that were introduced changed and evolved over time. The Swedish regime did, the Danish one. Now, both of them have obviously been phased out in light of same-sex marriage, but you had the controversial bits in those Registered Partnerships Act omitted in the beginning and then inserted in when they became more acceptable, thinking peer adoption, for example. We also find that, as I said, equal civil partnerships were this reaction. It wasn't in any way really a principled type of reform. Also, they weren't really pushed that hard back in 2002 when we started having conversations about civil partnerships. Here, probably because there was no lobbying organisation to really take up the cause. So in terms of the misunderstandings, we do see that the regime is a little bit uncertain. It's a bit complicated. For example, the sexual content of the relationship has now been added in. So originally civil partnerships were meant to effectively be non-conjugal. It was not something that they wanted to look at and test. And now we have a statutory parta est presumption that is applied to mixed sex civil partners. So we're retrospectively adding in a kind of sexual dimension given the composition of the couples. We have also this revisionism too, which is interesting. So Maria Miller, who was basically saying in the same-sex marriage debates how civil partnerships were inferior and that we really need marriage, she then comes out and starts saying how civil partnerships are really valuable and a well-understood institution. So the mixed messages are all over the place. So I want to now look at really that contribution of civil partnerships to cohabitation reform. So before 2000, naturally, we had cohabitants. They were litigating cases. They were doing things in the courts, but they were subject to the rudimentary implied trusts, as they still are now. And before 2000, it was really the can marry argument that was being used. Cohabitants were seen as vulnerable, Burns and Burns, etc. But you could have just got out of that vulnerability if you just married. And then in the early 2000s, we get a little bit of agitation for an opt-in registration scheme through Jane Griffiths' civil registration bill that she introduced in October 2001. And then also Lord Leicester's civil partnerships bill that he introduced in 2002. Jane's bill was quite interesting because she used letters from her constituents saying how some of them were left vulnerable by the lack of protection. And she used this one letter from one constituent who had been with their partner for 12 years. And I quote, "It was as though I didn't exist. I have no status. There's no word in the English language to describe what I am to John, her former partner." It didn't really go anywhere, that particular bill. And then Lord Leicester pushed his bill in the House of Lords. Now, both of them were offering mixed sex. It was not just exclusively same-sex civil partnerships, that it was open to both. But it was felt really in the later Civil Partnership Act that the real vulnerability lies with same-sex couples who had no method whatsoever of formalising. But within these early debates, you see some, again, misconceptions and just rather curious elements that I think have perhaps influenced later civil partnership debates. So we have the choice narrative coming up quite a bit. Lord Leicester's talking about how it's unjust to continue to penalise couples choosing not to marry. We have a curious blending of opt-in and opt-out elements. So Lord Leicester's bill it's a registration regime, but it had a requirement that couples had to cohabit for 6 months before they would be eligible to register. And then curiously, as you'll see from later slides, we've got this weird progression to marriage idea. So people were saying, perhaps to try and take the sting out of the controversial nature of this reform, was to say, oh no, these couples will enter civil partnerships, but then they're later going to marry down the line. Now, let's fast forward to the position around the time of Steinfeld. And so here we see more worrying misconceptions, and these are coming out of the parliamentary debates. So one idea that comes up quite a bit, and I get very annoyed about, is this idea of civil partnerships have this lighter form of commitment. But civil partnerships, as we know, are marriage in all but name. In terms of the legal intensity of rights that you're going to get, it's identical to essentially what you'll get under marriage. So it's not this kind of lighter, looser type of relationship. Again, mangled interpretations in relation to the Pax or the Belgian regime. There were some observations made in the House of Commons about how civil partnerships were a way in which partners could confer each other rights, and that they didn't go so far as saying you could personalize it as such, but I have seen some reports to suggest that it could be something that you can pick and choose rights. But as we know, marriage and civil partnership, it's a one size fits all. Cheaper, this idea that civil partnerships might be cheaper. Again, there's nothing really in that. You can have a stripped back marriage and an incredibly lavish civil partnership. It doesn't work that way. There's been misunderstanding about how civil partnerships have to be fully secular, and that overlooks the idea that from 2010, civil partnerships could actually be registered on religious premises. The pathway to marriage argument, I mentioned that, but that's still there. This idea that people will gradually gravitate towards marriage. But why would you do that if you have a civil partnership that gives you effectively all the rights as if you were married? And probably one of my favorite examples of this is Isle of Man. Now, Isle of Man were the first jurisdiction to actually introduce mixed-sex civil partnerships on the British Isles. And the first couple that actually entered into one, Adeline Cosson and Kieran Hodgson, are really quite curious because the Equal Civil Partnership campaign obviously wanted to support them. They thought it was a great thing. Some of the members of the Equal Civil Partnership campaign went over to the Isle of Man to enter a civil partnership, which wouldn't be recognised back here. And the thing that was curious is that Adeline and Kieran, first of all, they didn't actually know that they were the first on the island to enter a civil partnership. So everyone was saying, oh, you're trailblazers, and they just had no awareness of this. And secondly, they then go to the press, BBC News, Guardian, saying, oh, actually, we're going to marry in a few years' time, which I think is quite curious. And maybe, and this is supposition, because Adeline was French, I do wonder whether or not there was an idea of the Pax influencing her views there, and that it could be something more of a low-level registration regime, and maybe there was a bit of misunderstanding. So we do see a lot of overclaiming as to cohabitants as beneficiaries here. You can understand perhaps why the Equal Civil Partnership campaign wanted to connect to cohabitation reform. So Charles Kyde and Rebecca Steinfeld on the steps of the Supreme Court said that they took that case all the way up there for the 3.3 million cohabiting couples. Tim Lawton, in all of his representations in Parliament, constantly talked about the numbers of cohabitants and said this is going to help them, this new regime that they can enter into. Now, Rebecca and Charles have slightly changed their argumentation about civil partnerships. They started to push the cohab angle in the early days of their campaign, but then later on they started to say, well, no, actually, we need cohab reform in addition to civil partnerships. They started saying that we just felt marriage wasn't particularly right for us. So in terms of where we are currently, so as I said, New Year's Eve, the jubilation, we had 167 mixed-sex civil partnerships registered on that day. Not particularly useful, and the Office of National Statistics said that's all you've got, because obviously it's one day for that year. The interesting thing is the Government Equalities Office impact assessment. And in 2020, it was saying that you had variation in terms of how many people might actually enter. So it could be 84,000 couples entering in 2020, or it could be as low as 2,600. And I'll go later on in the following slides as to how many couples actually did register a civil partnership in 2020. But before I do that, some of the interesting things that you see in the media discourse can be teased out. So first of all, we introduce mixed-sex civil partnerships, and then the COVID pandemic hits. And quite curiously here, you find that, well, there was a reduction in ceremony sizes. You had, obviously because of COVID measures, you had couples saying that they would prefer to postpone actually entering their civil partnership so they can have a larger ceremony or registration, more friends there. And so that has to be taken into account when we start to extrapolate trends. 2020 was not a good year for marriage or civil partnership. But when you look at the a date to celebrate, which was the hashtag that they were using promoting their campaign, you do start to see that equal civil partnerships have this idea of smaller ceremonies, a little bit more informal, hopefully not misguided in terms of the law and the rights they ultimately get. Questions more into, discussions happening in relation to their egalitarian nature. And people saying that it's all about choice and autonomy. Equal Civil Partnerships campaign, never missing a trick, obviously then went wild with merchandise. And as you can see, some couples had their own face masks for their civil partnership ceremonies, and they've also got branded ones. Curiously, they also introduced a Equal Civil Partnerships apron, which is interesting. And then later, they actually introduced, or they were looking for a symbol that equal civil partners could have. And in the discussions online, some people were saying, oh, we should go for a ring. We should go for a ring. And I thought, of all the things you could actually choose, the ring probably is not the one that you think will probably best give effect to what you're wanting to do here. But you can see, I think, the way in which they did work in the social media age was they did bring a community of like-minded individuals together. That certainly did give that campaign movement momentum as well. But it did also, as Anne was saying, it did give that idea of this ideological, strong, driven set of couples wanting to enter this relationship. So the recent statistics then, in terms of uptake, is in 2021, there were 6,731 civil partnerships entered into, a decrease of from 19.4%. So in 2020, there were 8,351. So those are the totals across same-sex and mixed-sex. So as you can see immediately at the very low end of the government impact assessment. We do have to take into account, as I said, the COVID pandemic, but it certainly wasn't people marching through the doors trying to enter into registrations. Another thing that I find quite curious as well is the age distribution. And I'm conscious that Rosemary's in the audience who has done a lot of research on this. The age distribution of people entering into civil partnerships. And here you have generally older couples entering into them. And so we find that more than half, 58.1% of all people forming opposite sex civil partnerships in 2021 were 50 years of age or over. Whereas this age group accounts for 44.9% of same-sex civil partners. Now, that age group could be attributable to pent-up demand, a lot of couples wanting to actually kind of register, and then suddenly we were able to have that. But we have to think about that. And Jens mentioned earlier about whether or not we might see a development of our civil partnership regime, perhaps along the lines of the French pacts, kind of slightly older couples, educated couples, middle class with children. Are we going to see that demographic coming out there? Now back to my hobby horse, which is the Women and Equalities Committee inquiry. In terms of the evidence that was presented and all of the oral and written evidence presented, the report was quite clear that civil partnerships were not the solution. Said that it would be available to or attracted to a statistical minority of couples, but it's not going to solve this particular issue. The ideologue couples would be attracted. But then in the oral evidence sessions, and I'm not giving anything away here, they're all freely available to watch, you find the government position is really quite curious. It's almost as if they went in and someone briefed them to say, you need to really push marriage and obviously civil partnerships. So Tom Pursglove, who was giving the evidence as the then Minister of Justice, was saying that civil partnership will resolve quite a lot of challenges in this space. They won't. That they're a good thing, that it's a significant step. Also, we see the low-cost option coming in. And that could be interesting to note in the sense that ceremonies often cost a lot of money. And so civil partnerships develop a kind of a pattern whereby they're a little bit more stripped back, then maybe that could be quite attractive for some couples. Neil Barlow, the director of Family Justice, he gave evidence alongside Tom Pursglove and said that civil partnerships were capable of busting the common law marriage myth, and that it was all about allowing couples to regulise their position. And I find this is a curious observation, particularly when we know that the government's response is effectively, we're not going to really do public awareness campaigns. So they're saying really that if we told people about civil partnerships, that might mean that they'll enter into them, but then we're not going to put any financial backing or money into a public awareness campaign for that purpose. The chair of that committee, obviously Caroline Noakes, was very keen to push back on some of those observations about civil partnerships. Again, saying that it's not really the way to sort this out, and noting the fact that cohabiting relationships obviously are fluid and develop perhaps over time, and it might not come along at a convenient moment in time. Just to conclude then, essentially, we need to break this connection between cohabitation reform. Obviously, empirical studies have to look at marriage, cohab, and civil partnership together and cumulatively. But I think we do need to stop that connection being made as to equal civil partnerships being a solution to cohabitation. We haven't sorted it out yet. We need an empirical longitudinal study that can be, we can get a better sense of couple perceptions, both same-sex and mixed sex, to give a sense as to the longevity of the regime. Is it going to actually run its course, or like the New Zealand civil union scheme, is it really going to effectively wither on the vine? I think one thing that will help in that is that we're going to shift. We're going to shift from what I would term the champion cohort, the ones of the Steinfeld and Kaiden ilk, to others who are going to maybe in 10 years be given that menu of options of formalization, perhaps non-formalization, and then make a choice that isn't as conscious of really the battles fought for equal civil partnerships. Thank you.
Okay, so Brian, I've made you co-host now.
Yes, just hopefully sharing my slides now. Thank you. Yes, I can see the image of my slides on your screens. That's a good sign, and obviously you can hear me. So thank you very much for inviting me to speak today, particularly to Jens and Andy. Unfortunately, I wasn't able to make it there in person, but I hope that won't have too much of an impact on either my presentation, hopefully, or the discussion later. So I've been asked to speak about the intestacy rules and family provision as they were considered by the Law Commission, really quite a long time ago now, but there are some recent developments there which have already been alluded to. So I thought, well, a good place to start, and I've stolen a table from my own book, is to think, well, what do the intestacy rules actually look like? Well, as many of you will know, they're very generous to surviving spouses or civil partners. And the majority of estates will go entirely to such a person where there is one. If there's no surviving spouse or civil partner, the estate will essentially go entirely now to any issue. Now, lots of other categories of relatives are included if there is no spouse, civil partner, or issue that survives the deceased. So, for example, via the statutory trust, even your cousins could potentially inherit from your estate if you die intestate. But you'll see that cohabitants do not appear there at all. Now, one response to the absence of cohabitants in the intestacy rules in England and Wales is to say that, of course, if you want to include your cohabiting partner in your estate, you can just make a will. But while the figures on this point are difficult to estimate, it was suggested by the Law Commission in 2017 in its Making a Will project that 40% of adults in England and Wales don't have a will. And the empirical evidence suggests that cohabitants, if anything, are less likely to make wills than those who are in a marriage or a civil partnership. And that's despite the very fact that spouses have less need to make wills potentially, because the generosity to their surviving spouse or civil partner will probably take care of many of the worst situations that would otherwise arise. It's cohabitants who really need to make wills if they want their surviving partner to inherit, but they're much less likely to do so. And in this area, there is obviously a link to the common law marriage myth, but I don't need to say any more about that because it's already been explained very eloquently by Anne Barlow, and I can't possibly add to that, but it is part of the picture here. Now, another response to the absence of cohabitants in the intestacy rules is that a surviving cohabiting partner can simply make a family provision claim. And indeed, as many of you will know, the 1975 Act allows certain categories of applicant to bring a court-based claim for discretionary provision from an estate on the basis that the will and/or the intestacy rules don't make reasonable financial provision for the applicant. The section that we're really interested in here is section 11A, which includes amongst eligible applicants those who've lived with the deceased for 2 years immediately preceding death in the same household as the deceased spouse or civil partner, despite not in fact having formalized their relationship. And we heard a lot this morning about marital analogies. But as we'll see, there are serious issues raised about whether cohabitants should be included by default rather than having to make, or at least threaten, a claim under this legislation. The Law Commission in 2011 recommended that qualifying cohabitants should have the same entitlement as spouses under the intestacy rules. And I need to unpack the definition of what they meant by the qualifying cohabitant. And again, this ties up with much of what we've heard about other jurisdictions earlier in the day. First, you could be a qualifying cohabitant only under the Law Commission's recommendations if the deceased didn't have a subsisting marriage or civil partnership at death. So one immediate concern was taken care of in the sense that the surviving civil partner or spouse, if any, would still have priority over a surviving cohabitant. So one route to eligibility as a qualifying cohabitant under the Law Commission's recommendations was that you were living for 5 years as the deceased spouse or civil partner. You'll note that that's a longer period than is required for eligibility under the 1975 Act, and I think it takes account of the default or automatic nature of inclusion within the intestacy rules. An alternative route was through 2 years of residence if you had a child together, and the qualifying cohabitant was also living with the child at the date of the deceased death. So those were the basic recommendations of the Law Commission on the intestacy rules back in 2011. And they justified those recommendations, as I've summarized here, on the basis of the increase in prevalence and/or acceptability of cohabitation, which is a trend that, as has been pointed out earlier, has very much continued. They also referred explicitly to the common law marriage myth and the hardship that would be caused when people realize that they're not automatically included. They also said that it was undesirable for people to have to at least threaten litigation to get provision from an estate. And I think there's an irony here in that, in many contexts, we're trying to discourage people from litigating or even threatening to litigate, whereas here we're actively encouraging it, and the Law Commission wanted to address that. On family provision itself, they recommended the abolition of the 2-year residence requirement under the 1975 Act, where the deceased and the applicant had a child together. So essentially, a child in both these areas was treated as evidence of commitment within a relationship. And Jens talked earlier about the use of children as a kind of signifying factor in the recognition of de facto relationships throughout many jurisdictions. As many of you will also know, the current position is that cohabitants, unlike spouses or civil partners, are effectively limited to maintenance under the 1975 Act. The Commission also considered, though, that cohabitants shouldn't be subject to that limitation. So surviving spouses and civil partners don't need to show a need for maintenance, and they can also get enhanced provision with reference to what they would have got on divorce and dissolution. The Commission had previously proposed that cohabitants should no longer be limited by maintenance, but ultimately they dropped that particular provisional proposal because there was no equivalent yardstick of divorce on that divorce expectation for cohabitants. So that particular provisional recommendation was not taken forward. But in any event, the cohabitation recommendations in general were not implemented by the government at the time or any government since. And in 2022, as part of the Women and Equalities Committee report that's already been mentioned several times, there was a strong recommendation that the Law Commission's own recommendations should immediately be implemented, because the social picture that the Law Commission had identified in 2011 was still very much present, and people needed the kind of certainty that default provision in the intestacy rules would bring about. But in October, alongside their general skepticism about the Women and Equalities Committee's view, the government rejected implementation and said they needed to consider the recommendations on intestacy and family provision as part of the wider reform of cohabitation, which was itself going to be delayed. Now, they referenced the political contentiousness of inclusion of cohabitants within the intestacy rules. And that was something that the Law Commission itself had acknowledged. And so essentially, albeit many years later, the government were seizing on that and using it as a reason not to implement the recommendation. I think there's a really interesting use of language here in the government's response to the Women and Equalities Committee. And I know it's easy, perhaps, to read too much into language like this, but they tellingly, I think, talk about the prioritization of cohabitants over family members, and they see that as a bad thing. I think it's really significant that they're not saying other family members, they're talking about prioritization of cohabitants over family members. So the implication here is that cohabitants are not themselves members of the family. Children are, but cohabitants aren't. That's what the government seem to be saying. And as we've heard about already, that is totally contrary to how so many people now live their lives and what they believe. So there's a real othering of the cohabitant here, which I think is really problematic in contemporary social circumstances. Now, of course, there may be some circumstances where there is a contest on the deceased death between a surviving cohabitant and children of the deceased's earlier relationships. We're all aware of those, either whether we've personally encountered them, whether in practice or otherwise, or just anecdotally. But I think this response ignores the fact that in many circumstances, the deceased children will also be the children of the surviving cohabitant. So there isn't really a contest in the same way, and this is about supporting the family unit, the surviving family unit as a whole in many circumstances. And I think it's still preferable, as I mentioned earlier, to avoid the complications of threatening litigation and/or of the statutory trusts that would come into operation where the children are still minors. I think there is insufficient justification here to avoid automatic inclusion in the rules for cohabitants. So I just want to bring some of my thoughts to a conclusion, but I'm very happy to take questions and to debate further in the Q&A. I think we have to admit that cohabitants in the realm of succession law are not treated as badly, although I realize that's potentially a contested term, as they are in other areas. So, for example, in a context of inter vivos relationship breakdown, there's no real comprehensive scheme of statutory property redistribution at all. In this area, there is the possibility of a family provision claim on intestacy. But, as I've been arguing, the potential need for at least the threat of litigation to provide the security that a cohabitant might need is undesirable. Political controversy will exist. I think, though, there is an irony in the sense that we've been living under conservative governments for a while. We currently do, but it's not that long ago where a conservative prime minister was the first one that we know of to cohabit informally with his partner in 10 Downing Street, albeit that he and his partner later married, as we know. I think there should be less political contentiousness in circumstances where relationships have subsisted until death. So this is not a circumstance where people are living together informally, they then break up, they both need to carry on supporting themselves, and there's the question, well, why should I support that person who's left me or who have chosen to leave when I didn't marry them? Here, it's not about that, because the emphasis in the Law Commission recommendations would have been on relationships that subsisted until death. And the absence of controversy here, relatively at least, is borne out by public opinion evidence that was considered by the Law Commission itself. There's also, of course, the fact that cohabitants, as I mentioned earlier, have been included in the 1975 Act for nearly 30 years. Even under the John Major government, this was seen as a not particularly contentious inclusion. And all we're doing by including cohabitants automatically in the intestacy rules is acting consistently with the 1975 Act, but adapting the succession law picture to contemporary social conditions and making things easier. I do have to admit that there may be some practical problems in some circumstances of defining what a cohabitant is. And we've had some reference to that already, for example, in relation to Ireland. We have to be mindful of the fact that this definition may have to be applied by a layperson who's found themselves as the administrator of an estate where somebody hasn't made a will. It may be easier, of course, to produce a marriage certificate and say this person was married, therefore the entitlement of the spouse under the intestacy rules is clear. But that hasn't prevented the inclusion of cohabitants in the intestacy rules in other jurisdictions. So I don't think that that is an insurmountable obstacle at all. And I think there is a strong case for the inclusion of cohabitants within the intestacy rules, notwithstanding the political controversy that might arise. So I think I'll leave it there, but I'm very much looking forward to your questions. Thank you very much.
Oh, there she is. Okay, that should all be all okay, Rebecca? Great.
Yeah, I'm hoping that you can see my slides. Excellent. So thank you for the opportunity to present this particular research project today, and apologies for only just joining you. I was teaching until 2:30, but as I was teaching on this very subject, I wanted to be there to share this, share the law with my students. So what I'm going to talk about today is the topic of religious only marriages, drawing on a Nuffield Foundation funded project led by Dr. Rajnara Akhtar, on which I was a co-investigator. And religious only marriages are relevant to the topic today because, of course, those individuals are effectively cohabitants in the eyes of the law and don't have the same protections as they would in a valid or even in a void marriage. So just to give a quick overview of the project, we looked at a wide range of non-legally binding ceremonies in different communities. We were interested in investigating what kinds of ceremonies people had, why they were opting for these non-legally binding ceremonies, and also in investigating the impact of the Law Commission's proposals for weddings law reform. And we looked at both religious and non-religious marriage practices. So we wanted to find out who was opting for them, and also the role of those who was performing these ceremonies. My focus today, however, is going to be specifically on those couples who had a non-legally binding ceremony, either only or first. But this was quite a significant cohort within our study. So altogether, 9 participants had a non-legally binding ceremony over a month before they went through a legal wedding ceremony.
So I tried to interrupt you, Beck. We can't actually see the slides. We can see the first slide, but not the rest. I think you need to go to the slideshow.
Sorry, I've got a laptop and 2 screens. I'm trying to work out which things I need to press. Bear with me a moment. that moved it? No. Okay. I'm really sorry. I'm not sure I've got the means to move the slides because they're on a different screen.
Are we sharing the wrong screen, perhaps? Right, okay. So it's her end.
Yeah. Yeah, maybe come out. Yeah, stop.
Yeah, I'll try again. Sorry.
Yeah.
Yes.
Is that right? And now I'm completely the wrong one. So let me just scoot back. Right. Okay. So this is slides I was talking about in terms of the couples having non-legally binding ceremony either first over a month before the legal wedding, or couples who are in a religious only marriage at the time of the interview. So 2 points there. First, it's not an issue that's solely confined to Muslim communities, but it was predominantly among our Muslim interviewees that we had the non-legally binding ceremony either first or only. So the 24 Muslim interviewees who had non-legally binding ceremony were the majority of our Muslim interviewees. Very few had the legal ceremony first. Among our other interviewees, it was common practice to have the legal wedding first and then to go on to have a religious or non-religious ceremony. So although we had 4 individuals who did have a non-legally binding ceremony who were not Muslim, they all had very specific reasons for doing so. So the question is really, well, why do Muslim couples specifically have a non-legally binding ceremony? And there's sort of a couple of really key reasons for prioritizing the nikah. All of our 24 Muslim interviewees said that for them, the nikah was what made them married. If they didn't have the nikah, they wouldn't regard themselves as married. So various quotes here: it's the only valid form of ceremony in terms of my religion. As a Muslim, you're only married once you've had the nikah. It was also significant that none of these 24 interviewees had lived together before the nikah ceremony. In fact, some of them had had very limited opportunities to meet each other before the nikah. They had been permitted to sort of meet in the company of friends and family, or potentially in public places. We had a question for all of our interviews about whether there'd been any form of intimacy before the nikah, and one couple sort of said, well, we held hands, but they hadn't gone any further than that. So the nikah was a prerequisite for them having any kind of intimate relationship. And you can understand why couples who've had such limited opportunities to get to know each other might not want to embark on a legally recognised marriage immediately. When it came to why imams were willing to perform non-legally binding ceremonies, again, this mapped very much onto the reasons why couples wanted non-legally binding ceremonies. Imams shared the view that the nikah was the marriage, and that was what was the priority. They also wanted to make sure that couples weren't engaging in relationships that Islam would regard as sinful. On a practical level, though, imams also reported certain hindrances in being able to conduct legally binding weddings. So many of them were people who just did non-legally binding ceremonies. They operated outside any kind of mosque, but some were affiliated to mosques and some wanted that mosque to be registered for weddings so they could do legally binding weddings. But as the quotation on the screen shows, they reported that the process was very slow. We applied for registration at the centre last year. We're still here now, months on, with no paperwork, continuous headaches. I don't understand what's going on. We did apply for being registered. And when it came to the possibility of being appointed as an authorised person, similarly, many imams didn't know that that was an option. Some of them were delighted when they found out as a result of being interviewed that this was a possibility and said that they were going to apply to be authorised. But one of them asked quite pertinently, well, why do local authorities don't tell us that we could do this? Because then we would know how to register our buildings, how to become authorised to be able to preside at legally recognised weddings. So there was a lot of uncertainty, a lot of misunderstandings, or lack of understanding about the law. So within our sample, we also looked at why couples delayed or omitted the legal wedding altogether. And there were a number of reasons here. So first of all, among those who were delaying it, some identified particular legal or administrative barriers. So our empirical research was carried out at a time when there were restrictions on having legal weddings because of COVID. So the Sikh interviewee, who was in a non-legally recognised marriage at the time of the interview, had actually given notice to get married in a registered place of worship. But a few days before the wedding was due to take place, the registered place of worship had said that they couldn't do the ceremony because of COVID restrictions. But the couple went off and had a ceremony in an unregistered place of worship instead. Now, they had now given notice again and were planning to get married, but these, the legal restrictions imposed by COVID had a real impact on this sample in preventing them from getting married legally, but not preventing them from having a non-legally binding ceremony. There was one who was, their partner was subject to immigration control, and they pointed out that it would be much easier for them to sort of get permission to be married if they were living together, but they couldn't live together in the eyes of their religion and community unless they'd had the nikah. So they had their religious only ceremony, and then 2.5 years later, they went on and had the legal wedding. And quite a number just had difficulty in navigating the ordinary processes for getting married. They found the process of giving notice quite cumbersome, and just thought there was too much paperwork that needed to be filled in. We also had some who just simply, once they'd had the non-legally binding ceremony and started living together, didn't get round to having the legal ceremony for some time. So there was one couple that had their nikah, they started living together, they had a child together, they bought a house together, and eventually their family nagged them into having the legal wedding 7 years later. But there were others in the sample whose nikah had taken place equally long ago, who were still sort of saying, well, you know, life's just got in the way. We don't really see the point in sort of rushing into a legal wedding. We regard ourselves as good as married with the nikah. And there were a few cases of deliberate delay to test the relationship. Now, the most overt example of this was in the case of the Wiccan interviewee, who deliberately entered into a sort of test relationship for a year and a day before having a legal wedding. And this was particularly important to her to have that test because she'd been the victim of domestic abuse in a previous relationship. Now, most of our interviewees didn't articulate this idea of a test quite so explicitly, but they were certainly aware that it was easier to get out of a non-legally binding marriage than it was to get out of a legal marriage. And as I mentioned, some of them had entered into the nikah at a very early stage of their relationship. We then had some who simply didn't want to be legally married at all. So some mentioned the fact that if they were legally married, they would be liable financially to their partner. Interestingly, it was the women who were upfront about saying that they weren't getting married for financial reasons. None of the men explicitly said that. There were also potentially some where a legal wedding would not have been possible. We didn't have any direct examples of polygamous marriages within our sample, but there was at least one who suspected that her partner may still have been married to his first wife at the time that he went through a non-legally binding ceremony. And that the fact he was married was one of the reasons why he had ensured that the second ceremony was non-legally binding, so that he wouldn't risk prosecution for bigamy. And then we had a few who simply said that they didn't want to get legally married. One of the individuals who had an interfaith ceremony was someone who'd been married before and felt much more bound to her partner through the non-legally binding ceremony than she had in her previous legal weddings. Now, a lot's been written about the sort of misunderstandings of the law in this area. And it's possible that our sample was skewed because, of course, we were recruiting people in non-legally binding ceremonies. So it's possible that we just got the people who knew that their ceremony was non-legally binding, although we did try to frame the questions when we were recruiting in a way that would minimize that risk. But certainly the interviewees knew at the time of their ceremonies that what they were entering into was not legally recognized. So even if our sample was skewed, I think it was significant that these weren't people who'd realized at a later date that their ceremony wasn't recognized. They knew this at the time. There was just one who hadn't been aware and who suspected that her husband did know. This was the one who thought that her husband might already have been married to somebody else. But there was also a very clear sort of power dynamic going on here. And she sort of thought, well, he was sort of deliberately ensuring that this marriage wasn't recognized to ensure that he had all the power and she didn't. Within our sample, there wasn't actually any evidence of the common law marriage myth, which was interesting. We had one person who had heard that cohabitants might have legal rights, but she was very uncertain on that point, and it didn't seem to have influenced her behaviour in any respect. We did also ask people what they thought about the sort of state of knowledge in this area. And we found differing views there. So most interviewees thought that everybody knew that a NICA wasn't legally recognised. A few, however, thought that other people, not them, didn't know that the NICA wasn't legally recognised. So one said, you know, even educated women, their families told them, this is all you need to do. And then, you know, 10, 15, 20 years down the line, they find themselves in a really difficult position. So our research did illustrate the need for weddings law reform. So the Law Commission's recommendations would clearly have encouraged at least some couples to have dual ceremonies, by which I mean a ceremony that combines legal and religious efficacy. So the interviewees were very positive about the Law Commission's recommendations and thought that moving to an officiant-based system would be really helpful in allowing a wider range of religious ceremonies to be recognised by the law. So some of the couples who had had a non-legally binding ceremony would, I think, have been legally married if the Law Commission's recommendations had been in place. And that's true of those who had gone on to have a legal wedding, and also true of some who had not yet had a legal wedding at the time of the interview. But I think our research also shows that cohabitation reform is necessary for this group as well. So there are individuals who enter into religious-only marriage on the assumption that a legal wedding will follow. One of our sample, the NICA had taken place in 2014. They said, well, I keep assuming that there'll be something that triggers us having a legal wedding. But, you know, we've bought a house, we've had a child together. It's just not happened. And when you sort of read that transcript, you're sort of thinking, this is somebody who's incredibly vulnerable to the legal ceremony not taking place. So in terms of the practicalities, there might be a need to consider whether the same threshold conditions should apply to a couple who have had a religious-only wedding. Should they have to then satisfy all of the same conditions that other cohabitants have to satisfy, or should some account be taken of the fact that the couple have gone through a ceremony? But I think our research also shows that some couples definitely do want to opt out of legal protection as well. Thank you, and like Brian, I'm very happy to take any questions.
Okay, with that in mind, are